State of Michigan versus Tierra Richardson. And this is file number 24-01372, council appearance.
Morning, Your Honor. Case Mark Aaron appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Richardson, who is approaching council table.
It was next to it. That's right.
I just came off of that. We have to figure out what that is. Today was the date set for final pre-trial for a child abuse fourth degree. I believe that this was first set out because there was okay. My understanding is that there were some CPS records that needed to be shared. And an order was going to be needed. I don't know if that was addressed.
Yes, Your Honor. I believe it was addressed. I'll defer to Ms. Sutter if she said the time she needed to review them or not, but they weren't protected CBS records at first, so we did have to get order to release those.
I do know that I signed the order. I just don't know if they were turned over.
Yes, Your Honor. They were turned over to me. I was able to review them. We are ready to proceed today. There is an offer extended to Ms. Richardson. She just attached she wishes to accept it, so we're getting the paperwork filled out now. Please sheet and the advice break.
Okay, so I have a advice of rights and plea information sheet, and there's a plea offer here for you to plead to an added count 2 of domestic violence. Misdemeanor maximum penalty 93 days in jail and or $500 in fines. There's a Killebrew agreement to take parental responsibility classes instead of the normal batters and intervention program, and no objection to sentencing number 769.4A. Is that completely accurate?
Yes, ma'am.
Yes, Your Honor.
You want to accept that offer? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under the penalty of perjury? You put your hand down. You have the right in this matter to proceed to trial. You have the right to jury trial. That's because you are presumed innocent until proven guilty. That means you are innocent and you can require the prosecution prove your guilt by proceeding to trial, and they would have to prove each element of the charge being brought against you beyond a reasonable doubt. Do you understand that? You have the right to see, hear, or question any other witnesses that they intend to call to testify against you. You have the right to have witnesses subpoenaed to testify for you on your behalf at trial, or you can remain silent and not have silence be used against you, or waive your silence and testify at a trial if you like. You understand those rights? Are these all rights that you would like to give up? Oh. Anybody threatening you to get you to give these rights up and plead guilty to the amended charge?
No.
Are you currently on probation or on parole?
No.
Any promises being made to you if you plead guilty?
No.
Understand that by pleading guilty, it could result in a conviction that you may need to report to your current or future employer. It also could have impact or on where you can get travel or immigration status. Do you understand that? As to the amended charge of domestic violence. Are you sure?
This just sound crazy. Yes,
What do you mean? Explain to me what you mean.
I mean. Guilty.
No, I mean, I want you to explain to me what you mean when you said it just sounds crazy.
I mean,
You mean verbalizing it out loud
Yes.
and hearing it in your head is like throwing you off a little bit?
yes.
Okay. Are you sure you want to move forward today, or do you want more time? Okay. Okay. So are you sure that you want to plead guilty? Is that because you believe you're guilty?
I just want her home and. I was explaining.
No,
to me-
Ms. Sutter, your time to counsel is over when I'm talking to her. I asked her a specific question, so she's gonna answer that now.
So when it was explained to me, I guess the way that the law said, I guess I'm guilty.
Do you believe that you're guilty? Tell me what you did that you
Yeah,
think that would make you guilty of domestic violence.
Guess I pushed her.
You guessed, or did you?
I pushed her.
Did you push her?
I did.
Okay, was it in self-defense?
No.
Okay. So then what's the confusion part for you?
It just- I'm just not a violent person naturally, so there's no confusion.
Okay, I'm not asking you were you a violent person naturally. On this date and time, did you put your hand on Ms. Subtle?
I did,
Okay, and it was against her will,
yes,
and it was not in self-defense?
Yes.
Where did this take place?
my home,
What's the address?
858 East Green Line.
City of Lansing,
Yes,
Ingham County?
yes,
State of Michigan?
yes.
Okay. And who is Ms. Suttles to you?
My daughter,
What date did this occur?
April 2nd,
Of what year?
24.
So as to the domestic violence, you're pleading guilty, correct?
Yes,
Any additional factual basis?
No, Your Honor, the people are satisfied with the factual.
Not satisfactory.
The court is satisfied with the factual basis. I'll accept your plea and find your plea to be made free voluntarily and intelligently. This matter will be set for sentencing
February 10th, 2025 at 9 a.m.
February 10th, 2025 at 9 o'clock in the morning. When you leave, you'll go downstairs one floor so that you can meet with probation and check in. They're gonna get you prepared for a pre-sentence interview. There's a questionnaire you'll need to complete. They'll advise the court as to how they believe you should be sentenced and if you're eligible for sentencing under 769.4, okay? Let's see. You may appear for sentencing via Zoom. I'm assuming there's going to be a motion to amend the bond
That's right.
or the conditions of bond. Who does the child live with?
I believe she's currently residing with the grandmother.
Okay, which normally lives with you?
Yes,
How old is the child?
13, Your Honor.
Is the child here today? And there's no other CPS orders?
The CPS investigation was closed with no further actions.
Prior to these start taking.
That's correct. I think it was closed in May or June.
So you're seeking to have the child return home?
I am, Your Honor. Ms. Richardson has expressed to me some concern in the past that where she's currently residing, she is not being taken to her medical appointments, in particular some therapy appointments, and Ms. Richardson has been quite concerned with that because her daughter struggled in the past and she was just starting to get on a better foot for what Ms. Richardson has expressed to me, and she's concerned that her daughter's losing some ground and she would hate for that to happen.
I'll grant the request and amend the bond conditions to allow Ms. Suttles to return home and that there's only to be peaceful contact. I recognize your parenting, and so peaceful contact doesn't mean that you can't redirect or discipline your child in a manner that comports with the law. It just means that it shouldn't be any of the interactions that mimic what I see in the affidavit of probable cause, okay? Do you have any questions about that? You'll still go downstairs checking with probation so they can get you scheduled for your pre-sentence interview. You can complete the paperwork for that. Again, you can appear for sentencing via Zoom if you'd like, okay? Any additional matters for the record?
Nothing from the people, thank you.
Nothing further. Thank you.
You're all set for today. Ma'am. Your children. I have. Let's see. Mr. Wainwright. The record in the matter of the people of the state of Michigan versus Terrence Wainwright, 24-02176. Appearance, please.
Morning, Your Honor. Casey Markarian appearing on behalf of the people.
Excuse me, Your Honor. Jacob Riley on behalf of Mr. Wainwright.
This. Okay, today was the date and the time that was set for a final pre-trial on account of domestic violence. And we have witnesses here or how?
No, Your Honor, at this time, the necessary witness, Kayla Wainwright, has failed to appear. I have attempted contact with her one time. I successfully made contact with her. She advised that she just doesn't want to be involved. She wants the charges dropped and she wants nothing to do with this. I advised her of the subpoena, the date and the time for the final pre-trial. She made it apparent that she was not planning to appear. So the people are unable to proceed.
Defense request dismissal at this time. Your Honor.
Motion to dismiss is granted without prejudice. So that means that people do have the right to reissue this charge against you. Do you understand that?
Yes, Your Honor.
Do you have any questions for the court?
I think it's pretty straightforward. Thank you.
We'll get you a copy of the dismissal in just a moment. You're all set. You're welcome.
Just one thing, Your Honor, he does have a GPS. I want to make sure he gets that.
from this file. It will have staff email to have that removed. You need to go back to Ingham County for them to remove it, okay?
Oh, okay, down to the jail.
Yeah, they need to remove it, yeah.
Okay, thank you all.
You're welcome. Record in the matter of the people of the state of Michigan versus Isa Williams, 23-02992.
Your Honor, I believe Ms. Donnelly sent an email to your court with me CC'd on that one. This was the one, if you recall, where you advised he has a different hearing in a different county on the same date. We let the final trial date set. Your Honor advised at the last hearing that you could email to let us know if they're planning to set it for a jury trial, which I believe that.
So we are gonna continue to trial, okay?
Yes, sir.
Okay, let's see. Got Mr. McDermott in the?
Yes.
Okay. On the record in the matter of the people of the state of Michigan versus Vermont, McDermott, 24-02156, counsel appearance.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. McDermott, who joins us via polyconference.
Okay, today was date set for final pretrial. This is for an assault and battery. Yeah, witness here.
Yes, Your Honor. The necessary witness, Terry Reed, is here and present.
Okay, was there an offer on this?
Your Honor, there have been frankly a few different offers made on this, so I will defer to Ms. Sutter on what's going on here. I'm not sure Mr. McDermott plans to accept it.
That's correct, Your Honor. An additional offer was made this morning to Mr. McDermott that I expressed to him. He's asked some questions about it, and given that it does involve some other felonies going on, at this time, I would ask the court to reset this hearing to December 10th. At that same time and date, Mr. McDermott already has 2 hearings before the court. I'm sorry.
Today is December 10th.
I'm sorry, December 20th, I apologize. He has a preliminary examination and a contempt hearing on that day with yourself. And the offers thus far have involved those cases as well.
So global is what's considered.
That's correct, Your Honor. And if that is to be adjourned for that date, I would agree that Mr. Reed need not appear a second time for that.
And after hearing that date again out loud, Your Honor, I think did Your Honor maybe cancel the docket for that day? I'm not sure, on the 20th.
To reset to January
Yeah.
23rd at 9 AM.
I should have a document on the 20th. Should be, she should have unblocked that. and removed it.
Your PCCs are still.
Yeah, okay. Yeah,
PCCs are still there that day?
there should be PCCs there, no? They're blocked? Well, if there's PCCs, those would be blocked because I'm not here the following week.
Right.
But I am here on the 20th. Now. So it was blocked at one point, but over a week ago, she was supposed to unblock everything but.
Looks like you have some review hearings in the morning. And then
Did you
some
have-
civil
I do have several in the afternoon.
in around 10 o'clock. And nothing in the afternoon right now.
Okay, what was he supposed to have on that day?
Supposed to have a
Exam?
preliminary exam, so I think I canceled all our subpoenas.
Got it, and then we don't have enough time to do it, so,
He also on a different case had a contempt hearing.
yeah, that was moved to January.
Gotcha. Okay.
Okay, however, if you want me to set this matter for another date on that, on the 20th now, I can do that, and then if this can resolve it, we can take care of it. If we need to have the exam, we'll do it in January.
If the board's willing to do that, I think that would give both Ms. Donnelly, Mr. Austin, and myself the opportunity to meet with Mr. McDermott about the law firm.
Okay. We'll just set it for a possible plea on the 20th.
9 AM.
Okay, December 20th at 9 AM, we'll have this matter scheduled for plea, and again, if it doesn't resolve that time, we still have the January date for the date of the contempt hearing, I believe, and then the preliminary examination. Mr. McDermott, do you have any questions today so far?
The audio's not coming through, but I think he's saying no. Can you speak up a little bit, Mr. McDermott?
No question.
Okay. Sounds good. Any additional matters for the record today?
I apologize, just to confirm, because I don't think our files reflect the January date. Is it January 23rd at what time?
At 9 a.m.
Thank you. I have no further questions or comments for the record, Your Honor.
Nothing further from the team. Thank you.
Okay, you're all set, sir.
Thank you.
So this didn't break it, so somebody dropped this and broke it, and then they just sat pieces up there. Yeah, this is definitely, I'm looking at this thing because it doesn't snap in there. So when I saw that metal piece, I'm like, what is that?
It's the bottom.
It's the bottom. So one of them did that. And then they think they should have got it fixed. Won't stand it. Okay, sounds good. Do we have anybody else ready now?
I do not currently have anyone else here. Your Honor.
And we're running, yeah. Oh, actually, there's a Carmonique Williams here.
Was that Your Honor? I'm sorry.
Carmonique Williams is here via Zoom.
Thank you, Your Honor. Can I have briefly a breakout room?
Yes.
Thank you.
Carmonique Williams,
I'm here. I'm here.
please start your video.
Sure.
Okay, sounds good. Well, when she returns, we'll have her bring him up. Your attorney needs to speak with you, so I'm gonna put you in room 2.
Okay.
Sir, did you have a court date today? Remind me of your last name.
Alan, A-L-L.
Show cause. On the record in the matter of the people of the state of Michigan versus Tidonius Allen, this is in file number 23-02049. Mr. Allen, this matter was set for show cause because you were here back in August. And you pled guilty to the hinder opposed. The fine was $250. You were supposed to pay $170 by September 3rd and the balance by September 6th. And it looks like we gave you a 30-day extension back on September 9th, but it's now December 10th. You not paid that.
Paid $60.
You pay how much?
60.
When, today?
Yeah,
What's this balance, you see?
I know I still a high balance.
Balance was 190. You paid $60 on October 4th.
October 4th, you paid $60. Last week, what day?
As soon as I got back, after you gave me an extension, you said I could pay it. When I came back, I paid $60.
Do you have another file, maybe?
For no proof of insurance.
That was for your no proof of insurance, sir. You paid 60 on that one.
Oh, I didn't know I had it.
Yeah, you have
I would have,
you have two different files.
I would have been paying on both.
Okay, when are you gonna make a payment on this one? How much you gonna pay?
40.
When are you making the next payment? Next month?
Yes.
Today's the 10th, so 2 weeks from today is going to be the 30th. 31st. Pay $40 by December 31st.
Yeah.
And then you'll make another payment of how much notified by January
Um,
31st. I know you'll pay $40 per month until paid in full. You're all set. Are we all set with Ms. Williams in the breakout room?
We're trying to figure something out, Your Honor. So I can ask you, at plea, my notes and memory seem to tell me that I think Mr. Markarian requested immediate sentencing, but the court didn't want to do so without a CCH, an opportunity for victim statement. So I'm trying to recall, I don't believe there was a PSI order and I didn't receive one. I'm just trying to make sure that was correct.
PSI is ordered here. File. It's what the release is. Where's it? I don't have a probation file.
I can't hear anybody. They're talking, but I don't hear anything. Unless I'm not supposed to hear him talk.
Okay, on the record in the matter of the people of the state of Michigan versus Carmony Williams, file number 24-02702, counsel appearance.
Good morning, Your Honor. Case Mark Varian, appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lawrence Sutter, on behalf of Ms. Williams, who's joining us via Zoom.
Okay, Ms. Williams, today was the date scheduled for sentencing. I do have a pre-sentence report. It was prepared on the 4th of December. Your attorney did receive a copy today. You all went over that, correct?
Yes, Your Honor.
We need to make corrections, updates, or deletions.
Just a correction, maybe a couple corrections. Within the employment section, it indicated at the time of the report, she had a full-time position at Speedway. That is currently a part-time position. I think she was looking at getting employment somewhere else. So she stepped back her hours a little bit. So she's currently part-time at Speedway. She doesn't know her average income monthly right now, but she is making $14.50 an hour there. And then the other minor correction, within the overall impression, Mr. Neves indicated that she has been doing counseling since June. That was true until recently. She did stop the counseling because of an insurance issue. However, she's fully willing to become re-engaged back in mental health counseling, and is hopeful Mr. Neves might assist her in getting a referral somewhere. I have no further additions, deletions, or corrections to the PSI.
Make allocution.
Thank you, Your Honor. I did have the opportunity to review this report that Mr. Neves produced for us with Ms. Williams, and I do think it's a fair one. He noted in his impressions that it should be noted the defendant took full responsibility for her actions and indicated she was remorseful for what happened. I think that's also a fair assessment of Ms. Williams' attitude towards this case. That's how she's held herself out to me throughout the pendency of this as well, and that she acknowledges that some poor decisions were made here, and she is regretful and remorseful about them, and is willing to do what it takes to kind of put herself on a better path, both mentally as well as, you know, life-wise, in terms of making sure this is not a situation she ever could find herself in again. And to that end, I think the programs that Mr. Nev has recommended here are fair ones for her. I do appreciate that he made the effort of seeking out the Haven Wave group for her rather than the typical matters intervention classes, which would put her in a situation with primarily men doing any domestic violence probation. So I am appreciative of that. And again, Ms. Williams is fully willing and hopeful about re-engaging in mental health counseling, as the only reason she stopped was an insurance issue. So I would be asking the court to adopt a recommendation here. Mr. Neves did also indicate that there is an economic hardship for Ms. Williams as she is trying to deal with some back debt. And as given the correction I made with the court appointment, she has had to step back hours a little bit because she was seeking employment at a kind of move up professionally for her than a place like Speedway. And that's still something that she's working on. So I would ask the court to take that into consideration when assessing fines and costs today. Thank you.
For the record, I don't, if the public defenders are the case, I don't think I've ever assessed discretionary fines and costs. I always wait those.
I'm in the habit of just saying it anyway, Your Honor.
It's really, let's see here. Did your client want to say anything at all?
So Ms. Williams, this is the part where you can say something if you choose to. You do not have to if you do not want to.
Okay. As of right now, I think I'm okay. No questions.
Okay. Let's see. Today I reviewed the pre-sentence report with the recommendation, the prior criminal history, which there was none. I agree that I think the recommendation is appropriate, well thought out. Also, indicates that she is eligible for the special status 769.4A. So the court will adopt the recommendation. And 769.4A status will be granted. Let's see. We're on a term of 10 months probation. While on probation, you do need to maintain employment and provide evidence of that to your probation officer, okay?
Okay,
You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind while on probation. We'll continue the no contact order with Mr. Deshaun Williams. You're not to possess alcohol, marijuana, or a controlled substance unless you have a valid prescription.
And just as to quickly interject here, Mr. Neves did accurately note in the PSI that she does have a valid medical marijuana card.
There's a copy of that there as well. A copy of the card in the file.
Thank you.
You're required to submit to random preliminary drug testing and urinalysis testing, and you have to pay the cost of that, okay?
okay.
And you're not,
Okay.
yes, you had a question?
Yeah, I was gonna say, how much would it be for me to,
I think it's
to do
typically
that?
like a $90 to set it up, I believe. Don't quote me on that. And then,
Okay,
I
Like-
believe the per testing fee is $27.
yeah, I just know the large, there's a lump sum or a larger fee that you gotta pay to set up the testing, and then every time you drop, that'll, you have to pay the $27.
okay,
Let's see here. And I'm only ordering testing for the first 90 days.
Thank you, Your Honor.
Okay, and then I am going to order that you participate and complete the Haven Wave Women's Group.
okay.
Do you have any questions at this time?
No, ma'am.
Okay, there's a $75 crime victim rights fee that must be assessed per statute, plus a $50 state minimum cost that also must be assessed. Each month of probation, there's a $30 per month oversight fee. For 10 months, that's $300. I'm waiving discretionary fines and costs. So your total fines and costs is $425, but you'll make monthly payments on that, okay?
425, okay, let me write that down. I need a pen or something. Okay, you said 425,
Yes, that's for the total amount of fines and costs, which includes your monthly oversight fee, but you'll make monthly payments on that, and you'll also get a copy of the judgment of sentence that you'll have to review and sign off. So I'll have that on there as well as what your monthly payment should be to remain compliant, okay?
okay. So will I get all of that information with Nathaniel when I see him tomorrow?
More likely than not, yes.
Okay.
Let's see here. It's good for 2 days. 2 days.
Yes, Your Honor.
Okay, lastly, there was an advice of rights as to probation that you would have been provided if you were present in the court. It would advise you that you've been placed on a term of probation before the 54A District Court and that your terms are specifically tailored to address your assessed risks and needs. And that if you were not on a term of probation for domestic violence, you would have the right to request early discharge. It explains how and when you could do that. You are on a term of probation for early discharge. So you would not be allowed to request early discharge from probation. Do you understand that?
What does that mean? Like getting off probation early?
That's correct.
And you're saying that I'm not eligible for that?
No, because the one of the charges that is not eligible for that is a domestic violence charge.
Okay, okay.
Let's say you will have 769.4A status granted again, and I'm only ordering testing for the first 90 days to make sure additional programming doesn't need to be provided for you, okay?
Yes, yes,
After that
ma'am.
90 days, if we don't have any issues or violations as it relates to alcohol or drugs, then you will no longer need to test while on probation, okay?
Yes, ma'am.
Do you have any questions?
No, that's it. I have everything written down. Thank you.
Very good. So you'll follow up with Mr. Nabs. Any additional matters for the record today?
None from the people. Thank
Nothing
you.
further, Your Honor.
You're all set for today, ma'am. Thank you.
Thank you.
You're welcome. Okay, is Jeffrey Anderson here?
No.
You didn't see it? What about Joseph Johnson?
Yes.
Where is he? Oh, okay.
Your Honor, I think we're ready on, yeah, I've had Detective Kennedy waiting here since 8 a.m. this morning.
I recognize it. I'm just trying to understand who needs a benchmark. What about Melissa Orban?
No, she's not.
Okay. On the record in the matter of the people of the state of Michigan versus Ali Giat 24-02873, counsel appearance.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
Jacob Raleigh on behalf of Mr. Kiyet.
Okay, Mr. Giat was scheduled for final pre-trial and a PA 53 today. How are we proceeding?
Your Honor, it's my understanding the defendant is going to plead to the no contact violation regarding the underlying case itself. I have not seen the necessary witness, Crystal Bolden. I have made contact with her at some point where she indicated to me she did not want to proceed on these charges at anymore. So I didn't necessarily expect her to hear, but it was advised of her subpoena her date and time that she hasn't here.
Mr. Rowley.
Your Honor, yes, my client is not contesting the dismissal of the underlying case.
Okay, so you're gonna plead guilty to the bond violation, sir? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury? Okay, so I have a bond violation alleging that on or about the time frame of, when October 3rd, 2024 and October 18th, 2024, while at the Ingham County Jail that the defendant violated the conditions by making contact with Crystal Bolden by audio and video from Ingham County Jail. It was noted about 13 attempts to call and 3 answered calls. As to those violations, That's what you're pleading guilty to? You understand your right to have a contested hearing on this? You have the detective here ready to proceed, and you want to waive your hearing? To plead guilty to these violations? Anybody threatening you to do that? Any promises being made if you give up your hearing? As to the violations that was just read, how do you plead? Factual basis.
Again, is it true that you were arraigned by Victoria District Court in September of this year for abuse of alleged domestic violence?
Yes.
And as part of that arraignment, were you given certain orders that you were required to follow while the case was pending?
Yes.
It was one of those orders that you were not to have any direct or indirect contact with the alleged victim, Crystal Bolden?
Yes.
Is it true that you violated that order by attempting contact several times and making contact several times while you were in custody in county jail by phone?
Yes.
Any questions from the prosecution?
No, Your Honor, people are satisfied with the factual basis.
We're satisfied with the factual basis. I'll accept your plea if I see you make it voluntarily and intelligently. What will grant the judge motion to dismiss the underlying domestic violence without prejudice. That means that people have the right to reissue this charge against you. You understand that? You can address the court for sentencing.
Your Honor, I do want to remind the court that my client was sentenced to the remainder of the year in jail on the probation violation or the revocation of probation in a separate case. That is why he's still in custody at this point. As for these violations in October, I think my client was not making good decisions at that point. Clearly, I think he was kind of overwhelmed by the fact that he had been taken into custody and facing significant consequences for both of his cases that were pending at that time. Not to make excuses, but I just know that he would make a different decision today, and I think he certainly regrets violating the court.
This would be it. This would be the same. This actual case is what brought us, or brought you back before the court on a probation file that you were in the status of absconding on. I believe it was this particular file. And Ms. Bolden, in the past, in this file and in the others, was appeared before. Ms. Bolden appeared for a pretrial when she wasn't even supposed to be here, which to the court would reflect a willingness to proceed with these charges. But then, ironically, after 13 phone calls or attempted phone calls, and 3 answered calls, and then a video log that shows 5 video calls, 12 completed video calls. She no longer wants to appear to proceed in the case, and that's her decision. The court's concern is one of many, primarily the reckless and complete disregard for a court order. Not just in this file, but obviously the file that brought you in here still in handcuffs. And that's because you were on probation and you blew off probation and stopped absconding, even though your probation officer was very lenient. He allowed you to leave the whole state and move all the way to the East Coast without the court permission. I didn't find out until I got a request to issue a warrant. And I said, what's he doing in Maine? I didn't approve him to go to Maine. And then you find, so I issue a warrant. I reluctantly issued that warrant too. I almost didn't issue the warrant because I never approved you to go to Maine in the first place. So I wanted to understand, well, if I'm on probation and you let me go to Maine, I'm probably not gonna show up anymore either, right? Well, I issued it at his request, and then we get a new charge, a domestic violence, with your former co-defendant from the other case. And then she's participating up until a lot of these phone calls and some allegations of aggressive language relative to this particular case. It tells you that the calls were recorded, so you knew that when you made the calls and you said what you said. You didn't care. I recognize you're serving. How much more time he has?
I was outdated, Your Honor. I'm unable to access the jail system at this time, but I think it's sometime for the middle of 2025.
However, a bond violation could be served consecutive with and proceeding. I don't have to give you time served for that. I'm going to, but I don't have to. You need to make better decisions. I don't know what your relationship with Ms. Golden is, other than the fact that you still share a child in common. You should want to use this opportunity to redirect not just the allegations or behavior that caused the allegations in this file, but behavior in your other file too, so that you can be a better father, better co-parent, and if you all are going to continue your relationship, a better support for her as a man. The aggressive nature of the allegations in both this file and the other, it's not to be tolerated, and you shouldn't want that. You're supposed to be a protector. So I'm gonna credit you time served. You're all set. Thank you. What happened? Right, I'm kidding.
We use the term supervisor lightly with Mr. Martinez.
Well, I'm here because I heard there was some issue with your P number, some kind of glitch.
Yeah, right.
That's right.
There's a glitch with the P number?
No,
They retracted it?
Yeah, they found, everyone found out that I was lying the whole time about passing the bar. You know?
I'm
People
actually
do that.
I'm
Like
handling some
Ross
things
and
over in
Simmons.
Judge Ward's court, so I just figured I'd come over and say hello.
You said what's going on in judgment court?
I'm handling a couple
Oh,
cases
okay,
over
got
there
it.
this morning. Got some
Okay,
couple pro
well-
per defendants that are,
Sounds exciting.
you know, how that
Well,
goes.
Mr. Markarian's flying through over here. I'm going to
I'm trying.
Be on the record in the matter of the people of the state of Michigan versus Jasmine Hislop. That's 19-03270. Mr. Russell?
Yeah.
Okay. Okay, Ms. Hislop, this is retail fraud, 2019, that we have a warrant for. You want to see if this work? It worked. Thank you. Retail fraud from 2019 that you failed to appear on before Judge Alderson.
I was incarcerated. Work from my co-ops and if you would like it,
You were incarcerated where, ma'am?
Eaton County Jail.
We have that noted that you at some point were in Eaton County. However, there would have been a writ for you to appear after that.
They never took me on a writ. I was in Eaton County for 2 years and then I went to prison for 3.
Okay, so maybe you were in prison by then. Do you know when you were to?
Was 2021. but I
Oh, okay. Well, I'm not sure what happened. Nonetheless, your matter is, Judge Alderson is now retired. And so your matter is now going to be before Judge Flores, one courtroom over. And so your pretrial will be scheduled now for January 7th at 9:30, okay?
Okay. So I'm all set?
Give me just a moment.
Okay.
I think you previously had a PR bond. $500. Looks like. Yeah, that was back on October 10th, 2019. Say you were sick, you had failed to appear and you went to urgent care. So I'll reinstate the bond of PR. What's your home address?
6447 Narrow Lake Road, Charlotte, Michigan.
You said Narrow Lake.
Yes. Charlotte, Michigan, 48813.
What's your phone number?
517-588-8230.
Are you employed?
Yes.
I think you previously requested a public defender. Is that the case? Let's see. I think Mr. Lee is here, who is assigned to Judge Flores, and I'm gonna have someone message them so that you can get with him today and engage to see if that way he can make contact to see if there's gonna be an offer or if they need any updated information from you, they can do that, okay? On is again 500 personal recognizance. You can appear via Zoom for court. Did you get Zoom instructions?
No.
We'll get you a copy of Judge Flores' Zoom instructions, okay?
Thank you.
You're welcome. We'll see if Mr. Lee will tell that this case has been in a holding pattern since 2019, and they may need information from her. Mr. Riley, you have me ready to go.
Joseph Johnson.
On the record in the matter of the people of the state of Michigan versus Joseph Johnson, 24-02941, appearance, please.
Morning, Your Honor, case Mark Aaron, appearing on behalf of the people.
Jacob Riley on behalf of Mr. Johnson.
Date and time that was scheduled for a pretrial. This is for domestic violence. How are we proceeding on this?
Sign would be requesting final trial.
No offer?
Your Honor, the offer at this time would be to plea as charged with the Kilabruta substance abuse treatment.
How do you make your final pretrial instructions?
Just enough time for them to be able to send a subpoena. That's all I need.
January 13th at 8 a.m.
January 13th, 8 a.m. Final pretrial. You must appear in person. Yes. They have to appear first.
Be a jury trial there.
Jury trials.
February 24th at 8
February 24th at 8 AM. We'll get you a notice to appear. Do you have any questions, sir? No. Thank you. Any additional matters for the record?
People.
Oh, yeah.
You're all set for today. Well, this is in custody. What's going on with Johnson? Sean Johnson,
I think it's just a set.
is he here?
It is, Your Honor, and he is present. I think he may have stepped out of the courtroom, but he was here.
Yes, he is. Mr. Johnson is
Where
here.
is he?
Oh,
I believe he went downstairs to the bathroom, Your Honor, since I told him it might be a few minutes.
Are we ready on Mr. Russell?
Your Honor, I wasn't put into a breakout room with him.
Oh, okay. And who's this? Are you waiting for a court date?
Malcolm Bishop.
What about these individuals?
Yeah, I believe it's Mr. Elamine.
That is, Mr. Elamine is present in the courtroom. He is ready to proceed as well.
Okay, we can take care of that one first.
Being frantic.
Impeding traffic, you're accepting responsibility too, sir? You said yes. I can't hear it. You have to say it verbally.
Yes, ma'am.
Okay, it's $135. When can you pay? You said 30 days?
That's fine.
Yeah. Let me find your file. Okay, I'll know that you'll pay within 30 days. You can come up and pay in the criminal traffic window, or you can do it online if you want to use your court number, case number, okay? I'll put Mr. Williams in room, I'm sorry, Mr. Russell in room 2.
Thank you, Your Honor.
You're welcome.
You didn't need a plea sheet on that, did you?
I do not. You're all set, sir.
Thank you. Thank you, Your Honor.
Sure. Let's go find the file. On the record in the matter of the people of the state of Michigan versus Sean Alex Johnson, matters, that is, not matter, 24-00707, 24-02649, and 24-02966. Is that Ms. Sutter's place? Oh, okay, well, we gotta wait for your attorney then. You can have a seat. Who do you have, Mr. Raleigh?
Malcolm Bishop.
Record of the matter of the people of the state of Michigan versus Malcolm Bishop, 24-03252. Appearance, please.
Morning, Your Honor. Case Mark Therian appearing on behalf of the people.
Jacob Riley on behalf of Mr. Bishop.
Okay, Mr. Bishop, today was the date and time scheduled for a trial. This is for malicious destruction of property. How are we proceeding on this?
Your Honor, frankly, contact with the witnesses, the victims on this one has been a little bit difficult, ever since our preliminary exam that we attempted on this one. Their phone's been shut off. I've been able to have contact with them via email intermittently, and that didn't even really start until Friday. So I haven't had a chance to really consult with the victims about an offer on this one. I'm not sure if you would be willing to reset the pretrial so that I can come up with an offer on this one. The best I could do at this point would be to be discharged with a kilogram from jail. But I would like to potentially reduce it and provide a different offer once I've had a chance to consult.
You plan on increasing custody before I issue a control. Raleigh, how do you want to proceed?
No objection to that request, Your Honor.
Can we check this?
January 6th at 10 a.m.
January 6th at 10 a.m. January 17th. That's because it was this file. Okay. January 6th, 10 a.m. will be your next pretrial. Okay. Do you have any questions today? We'll get you a notice to appear. Any additional matters for the record?
Nothing from the people.
No, Your Honor.
So you're gonna contact to get before you can make an offer is what you're saying?
Yes, Your Honor. I have to at least attempt, under the Crime Victim Rights Act, I have to at least attempt to consult with them. I haven't had that opportunity yet. I just got an updated email address from them Friday by reaching out to Detective Jackie Lindman, who's been able to stay in contact with them. The problem is, ever since our preliminary exam, their number has been completely out of service. They are potentially moving, might not be, and their car has been in the shop, so they didn't have any transportation either.
Okay, so that was when I just looked at it again. It was actually when I looked at him and I was like, wait, I remember this file.
Yes, sir.
Let's see here. I don't know if it's more beneficial to have a final pretrial then. Just because if you're struggling to get communication with them. And then,
I wouldn't say I'm struggling to get communication
there's
with them.
some-
I didn't get updated contact information until this past Friday.
I get that. However, I don't know that there's many offers, and I could be wrong, that you could give them that he is gonna take based on how that final pretrial worked. I mean, that preliminary exam. I could be wrong though.
I've got a photo of some damage that I think is pretty clear, Your Honor. So I think this might be a different case than the actual preliminary exam.
I recognize that, but that doesn't, just because you have a photo of damage doesn't mean he has to plead guilty.
Sure.
And so I don't know that there's something that he's willing to take. So my thing is, I don't want to set it out just for them to say, set it for final pretrial. That's my only issue. We set it out for the 10th or the 6th, and they come back here on the 6th and say, we want a final pretrial. Now we got to set it out again.
I see what you're saying.
That's
but
my position.
I guess I'll leave it to the court's discretion at this point, but I frankly haven't had a chance to speak with Mr. Raleigh at all. on this case.
Mr. Raleigh has spoken to his client, correct?
Yes, Your Honor. I guess in light of this information, I think it might make sense to set the final.
We can convert the January 6th to final pretrial. And that will be at 8 a.m. That way, all parties need to appear in person. Do you have any questions at this time? Any additional matters for the record?
No, Your Honor.
No, Your Honor.
You're also for today.
Jury trial date, Your Honor.
A jury trial date. February 20-something.
24th.
February 24th, for jury trial at 8 AM. We'll get you a notice to appear in just a moment. You can have a seat, okay? Are you waiting for a court date, ma'am? So you're here with who?
John Johnson.
Oh, okay. Mr. Johnson.
She just stepped back out again.
And Miss Sutherland.
And Mr. Clark is not in custody.
Okay, I'll issue a picture. I'll issue a picture. See Franklin Miller here today. Here. I heard something print and wasn't.
Oh, that was a CCH.
Just printed the notices, they should come.
Are we ready on Mr. Russell? Mr. Russell? Mr. Russell, can you hear us?
Yes, yes, I can. Hold on.
Oh.
Sorry.
On the record in the matters of the people of the state of Michigan versus William Russell, 24-01854 and 853 appearances, please.
Morning, Your Honor. Case-
Good morning, Your Honor. Assistant Public Defender, Lawrence Sutter, on behalf of Mr. Russell, who's joining us via Zoom.
Today, the date set for pretrial. These are for unlicensed dogs. How are we proceeding on these?
Thank you, Your Honor. I'm going to be making an additional request for adjournment. Mr. Russell has been saying compliant by these licenses. He is an indigent individual, so it's taking him some additional time. I know the court at the last hearing advised us that you would consider national hearing. You just wanted to check in with him today. He did advise me this morning that he has set aside so far about $50 towards the cost of those licenses. So we'll be asking for some additional time for him to gather the remaining portion of the money.
How much do licenses cost?
It kind of depends on what's going on with the license, Your Honor. If there's a delinquent, I believe the price doubles. And I can get that number, but I don't have it on hand.
So he's got $50 saved for each or total?
He's
Okay.
got 2 dogs to license and that's the total he is.
I'm sorry? How do you read that,
$200 a
Mr. Russell?
dog. $200. Yes.
How long do you think it's gonna take you to get that?
I mean, I'm working on as much as I can. I only got a little bit I can set aside at.
Okay, give me a date and January.
January 13th. Yeah, 10 a.m.
January 13th at 10 a.m. You have any questions today, Mr. Russell?
Oh.
You're all set for
Thank you.
today.
Have a good day.
You too. What is this?
Mr. Willis, he's here for something.
That's CCH.
It's not, it's a registry of action.
See, I thought she printed it.
So I'm like, what is that?
You should have a file.
Why do we need a CCH?
No, I just.
Oh,
looked,
yeah, I
didn't
do have
read
it.
it.
I have a file.
Where's the-
Yeah, that's why I was like, I didn't, that's why I assumed it was that. I didn't
Oh,
even read
okay.
it.
No, I have it.
That was
I don't really see. What's going on here? Let's see. I don't know what happened with that. Today, Juarez. This be a contempt hearing?
For the Huelves.
It was a /contempt hearing.
It was, Your Honor. I don't have the necessary witness that I would need for the contempt hearing. I don't think so.
On the record in the matter of the people of the state of Michigan. Wait, he's downstairs though, isn't he?
Yes,
Oh, this is Heredia. I believe. Is that Mr. Heredia?
yes.
Sounds good. Okay, are we ready on Mr. Heredia? I have not seen. Brandon Brown. Hold on, that's in someone's file. These were the wrong. Failed to appear.
Ready?
Oh, sorry.
So I'm understanding what is this? Who printed this?
I don't know, it just showed up on the print.
Something else?
Do we have a contempt hearing on Heredia today, Your Honor, or is it just 3 trials?
I have 2 pre-trials.
So it's not- I didn't think it was-
Christian required, right? Fucking no. Listen. The few were actually.
Yeah, Mr. Heredia.
So, Your Honor,
Heredia, Mr. Heredia.
On the record of the matter of the people of the state of Michigan versus Antonio Heredia, 18-05847 and 24-01168, counsel appearance.
Morning, Your Honor, case of hearing appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Heredia, who joins us via Zoom.
Mr. Heredia has a malicious destruction of property and then a 2018 driving while license is suspended. Like this was previously adjourned for global resolution and then he failed to appear. How are we proceeding?
If I may, Your Honor, yes, it was previously adjourned for a global resolution as well as KCS going on the 30th Circuit right now. We'd requested a date beyond the 30th Circuit hearing, which was supposed to have been on the 5th. However, Judge Shamos court reset all hearings on that day, and Mr. Heredia has been reset for the 12th of this month. So I would ask the court to adjourn beyond the 12th so that we can get past that hearing in order to resolve this one.
That's the 12th of this month?
That's correct, Your Honor.
January 6th at 8:30.
January 6th at 8:30. Do you have any questions today, Mr. Heredia?
No, you are.
Okay, any additional matters for the record?
Running people.
Nothing further.
Okay, you're all set, sir.
Thank you.
You're welcome. I've not seen Mr. Brown.
Brian,
This was set for plea for him.
that's, Mr. Raleigh indicated to me his client wanted to take the deal today, so I guess I assumed they had spoken. I'm not sure if he's out.
Okay, what's going on with Dane Rollins? Have you met with him already? She's
Mr.
not
Rod
met
is out and all with Mr. Raleigh.
with Mr.
Oh, Dwell-based, I am handling for Mr. Michelson today.
Met with him.
I have, yes, Your Honor. This is Brandon Brown.
Oh, okay.
Yes.
We can bring up a date Wellness.
You already have a plea sheet on the Brown matter, Your Honor. Or do I fill out that?
I wrote in the file offer, would be right with first with restitution. That's the offer still?
Yeah, it is. I just don't know if we've submitted a formal plea sheet or not.
No, that's really for like more complex
Okay.
reductions.
Not gonna do the extra
Changing a
paperwork. You don't
second
make
to
me
a
do it.
first is fine.
Less paperwork is good for me. That's why I did this instead of some other paperwork.
Ready, if you're ready, Mr. Brown. On the record in the matter of the people of the state of Michigan versus Brandon Brown, 24-02855, council appearance.
Good morning, Your Honor. Case Mark Arian appearing on behalf of the people.
Jacob Riley on behalf of Mr. Brown.
Mr. Brown, today's the date that we set this for a plea, and that's for you to have had time to consider the offer, which is to amend the OWI second to an OWI first. My understanding is that you consider that you want to accept that offer.
Yes, sir.
You have advice and rights, counsel.
I do, Your Honor.
Thank you. Mr. Brown, please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury? Thank you. You can put your hand down. Okay, this is an advice and rights of information sheet. Has today's date on it. Your signature?
Yes, sir.
Did you read these rights?
Yes, sir.
You understand these rights?
Yes, sir.
You want to give these rights up? You do not? You want to keep maintaining the rights? So when I ask you that, is that in order for you to plead, you'd have to give these rights up.
Sorry, Your Honor.
Okay. So you want to give these rights up? Okay, you know,
Okay.
you sure?
What the plea you would be giving up?
Yes, I would like to do it.
Yeah, okay, because you read these rights, correct? So you know what these rights are.
Yes, sir.
That means your right to trial. Want to give up that right? You have the right to remain silent and not have silence be used against you at that trial. If you give up your right to trial, that means you would give that right up as well, correct? You have the right to see, hear, or question any other witnesses that the prosecution was going to call to testify against you. You could have subpoenaed witnesses to testify for you at your trial. You could waive your silence and testify on your own behalf. Those are all rights you would give up if you plead guilty. You understand that?
Yes, sir.
And then obviously the right to the presumption of innocence, meaning you are innocent as you stand there. You can maintain your innocence and require that they proceed to trial and attempt to prove each element beyond a reasonable doubt before you are deemed to be guilty. So you want to waive your presumption of innocence and plead guilty, correct?
That's correct.
Anybody threatening you to do that?
No, Your Honor.
Any promises being made in exchange for a guilty plea?
No, Your Honor.
Currently on probation or on parole.
No, Your Honor.
You understand that by pleading guilty, you could have impact on travel or immigration status that you may be seeking.
I do, Your Honor.
You also understand that by pleading guilty, you may need to report this conviction to the employer or put it on a future job application. As to the amended charge of operating while intoxicated, first offense, how do you plead? Is that because you believe you're guilty? Factual basis, counsel?
Mr. Brown, on the early morning hours of May 19th of this year, we operating a vehicle on, or in the area of Pleasant Grove in Belmont.
Yes.
Is this in the city of Lansing?
Yes.
Had you consumed some alcohol prior to driving?
Yes.
You have contact with police?
Yeah.
And, I guess following contact with police, did they make the decision to arrest you on suspicion of operating while intoxicated?
Yes.
Did they eventually do a, take you to a hospital where a blood draw was conducted?
Yes.
Do you agree that the result of that blood test showed that your blood alcohol level was above? Do you have any reason to believe that that was inaccurate?
Mark, there any questions?
Just one, Your Honor. Mr. Brown, did this occur in Hingham County and the state of Michigan?
Yes.
Thank you. People are satisfied with that.
The court is satisfied with the factual basis of not accept your plea and find your plea to make freely, voluntarily, and intelligently. I'm gonna set this matter for sentencing. We need to meet with our probation department so that they can prepare for a pre-sentence report. Provide a recommendation as to how you are to be sentenced, okay? So when you leave here, you're gonna go down 1 floor. To check in with probation, okay? You have not undergone a substance abuse assessment, you will be required to do so as part of that pre-sentence, okay? February. He's on. I had the wrong year. Oh.
February 11th at 9 a.m.
February 11th at 9 a.m. is going to be your sentencing date, okay? I think you would notice to appear in just a moment. Do you have any questions for the court?
Oh, yeah.
Any additional matters for the record?
Nothing from the people.
Oh, yeah.
You're gonna have a seat there. My court officer will take you down to probation in just a moment, okay? On the record in the matter, the people of the state of Michigan versus Luis De Jueves, 23-03533, counsel appearance.
Morning, Your Honor. Case marked Aaron, appearing on behalf.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter standing in for Assistant Public Defender Steve Feigelson today on behalf of Mr. Duelves, who is standing to my right.
Okay, Mr. Duelves has a K-53 contempt scheduled for today, as well as a sentencing. My understanding is that the witness on the contempt stop here, is that the issue?
Yes, Your Honor. The necessary witnesses to proving that contempt violations are not present. I have not seen them here today. My understanding that some of the officers might not have gotten a subpoena on this too, but regardless, I think we would need the lay witness on that case to really prove the allegations. And that lay witness also failed to appear at the preliminary exam for the felony charges that were resulting from the allegations.
So the
felony charges.
It's already been discussed.
Yes, Your Honor.
P53 is dismissed. And we've already got sentencing.
Yes, we are, Your Honor.
I have a pre-sentence report from November 12th, and you received a copy and gone over that already.
I did, Your Honor, and Mr. Feigelson and I reviewed it with Mr. Duelves yesterday.
You need to make corrections, updates, or deletions.
None of this time, Your Honor.
Can I just report?
Thank you, Your Honor. As I previously stated, Mr. Feigelson and I did review the pre-sentence investigation report with Mr. Duelves yesterday. There are no corrections, additions, or deletions to make. I would be asking the court to adopt the recommendation here. I think it is a fair and genuine one that was submitted by Ms. Bayless. They did indicate that Mr. Luis was drinking during the time of this incident, and as a result of that, they've recommended the outpatient treatment program here. That is something Mr. Luis is willing to participate in and thinks that there can be much gain from participation in a program like that. He does struggle, as he admits, with handling some emotions. So I think a program like probation can give him the opportunity to take advantage of some of the resources that individuals like Ms. Bayless can provide to him. He is a person who's willing to step up and kind of admit to the poor decision-making that has been previously taking place in this matter and do what it takes to learn from it, grow from it, and not put himself in the same position again. I would ask the court to adopt the recommendation here, that being the 10 months of reporting probation, along with the continuing no contact order and the participation in the anger management as well as outpatient substance program. Thank you, Your Honor. He does not wish to at this time.
I've read and reviewed the pre-sentence report, the recommendation, and the prior criminal history. The officer said the court should have concern about putting you on probation. You know why?
No, Your Honor.
It says that you have demonstrated some non-compliant behaviors in the past while on bond and failure to appear for all your legal requirements.
Yes, Your Honor. The previous requirements were for false probation and park after dark. I was in Clinton County, and I forgot to call back and schedule a court date for it.
Correct, but you had a failure to appear here as well.
Yes.
And then obviously we had a bond violation allegation, which is a concern about your willingness to comply with the court order. If I put you on a term of probation for 10 months, that means that there's some orders that you have to comply with for 10 months. First one being that you would not be allowed to have alcohol. You would have to report monthly. You'd have to undergo testing. There'd be some other requirements as well, but if you can't do something as little as show up to court for a pre-trial, how am I supposed to feel confident that you'll do all the other things?
Understand.
Well, that's a question.
Yes, I am willing to comply with the probation. I'm willing to go through the treatment to get myself together and stay away from alcohol.
I should hope so. I don't see where you've ever done probation. I only saw one other. Oh, you have done probation before, correct? A long time ago?
Correct, when I was 18, I believe.
Oh, sounds good. Okay, I'm gonna give you a chance on probation and adopt the recommendation. The recommendation is for 10 months probation. Okay, so we'll adopt the recommendation 10 months probation. While on probation, I'm gonna continue the no contact order with the Marilio Perez Santana. Julio. Also, while on probation, you're not to engage in any assaultive or threatening behavior. You understand that?
Understand, Your Honor.
You're not to possess a firearm, ammunition, or weapon of any kind while you're on probation. And you're not to use, purchase, or possess alcohol, marijuana, or controlled substance unless you have a valid prescription, right?
Okay.
You will be required to submit to random preliminary breath testing and your analysis testing, and you have to pay the fine for that, okay, or the cost of that. You're not to be at any bars or nightclubs while on probation. You will be required to participate in outpatient substance abuse treatment, and you must obtain and maintain employment. Do you have any questions about this stuff?
I do not, Your Honor.
My understanding is that you're currently without housing.
Correct, Your Honor.
Okay. What is your plan for housing when you release?
Stay at the Lansing Rescue Mission.
So you did not finish high school, correct?
Correct.
I'm gonna order that you enroll in a GED or high school diploma program. Is he being held on anything else other than this?
I do not believe so, Your Honor. I believe it was the contempt.
Took care of the warrants that he had? For child support?
I believe those primarily have been handled. They're all civil. I think he has to call the fourth, it was the fourth circuit regarding one, but my understanding from talking to Mr. Fragos is that they largely have been handled. He is aware that he should be calling all of these courts after his release to handle any outstanding payments that he can.
What's your phone number, sir?
Number is 517-394-4466.
894.
Correct. 4466.
As to fines and costs, there's a $75 crime victim rights fee that must be assessed, plus the $50 state minimum cost that will be assessed, that is. There's a $30 per month oversight fee, which you are responsible for while on probation. And so for 10 months, that's $300. You have any questions?
I do not, Your Honor.
I am also going to order a complete Ingram management proof as well. Okay. Waive discretionary fines and costs. Your total fines and costs will be $425. I recognize that finances are at this time concerned for you because you're not employed, but you're ordered to find employment. So you need to be prioritizing the employment, and you also need to be prioritizing enrolling in these programming requirements. And then obviously, when it comes to where you're spending your money first, if you're ordered to test, you need to do that. You understand that?
Understand, Your Honor.
Do you have any questions today?
I do not, Your Honor.
You're gonna need to check in with probation. We're gonna have you check in within 48 hours of your release to make sure they have accurate contact information for you, because they're gonna prepare a pre-sentence, judgment of sentence, that is, and you need to go over that with them, okay?
Okay.
Lastly, there's an advice of rights as to probation. It says you've been placed on a term of probation. Ms. Collins. Report to for a district court. I could be getting shanked right now. I'll give you an opportunity to review that. So no. I just had a whole conversation with you and you did not hear anything I said. Okay, so again, that advice of rights, it says that you would have the right to request early discharge from probation once completed, or once you would have completed half the original term ordered by the court, so long as you've not violated any of the conditions of probation within the 90 days preceding that request. You can make a request for early discharge by getting the court's NC 512 form. That's on the court website, or you can ask for a copy of that form from your probation officer, okay?
Okay.
If you complete the form, you need to file it on probation, and you have to get a copy. You'd be responsible for getting a copy to the prosecutor's office. They have 14 days to file any written objections to your early discharge from probation, okay?
Okay.
Do you have any questions about that?
I do not.
If I set it for a hearing to address your request for early discharge, you have the right to hire an attorney. You would not have the right to have a court-appointed counsel represent you for that hearing, okay?
Okay.
Did initial and date there for today. We'll get all this down to probation. Do you have any questions about your probation at this time?
I do not, Your Honor.
Any additional matters for the record, counsel?
Nothing from the people.
Nothing further.
Thank you. You're all set. I think that's all I have. I didn't see.
Jeffrey Anderson,
Who?
Jeffrey Anderson, bench warrant. It was at 8:30.
Oh, yeah, I did issue a bench warrant for Anderson and Orban.
Or been to.